In today's video, I'm going to explain what a hostile work environment is, and we are starting right now. Welcome to my channel. My name is Brandon Ortiz. I am the owner of Ortiz Law Office in Burbank, California, and I am an employment lawyer in California. Before we get started, this video is not legal advice. I'm just providing you with general information. If you have questions about your specific situation that you need help with, please contact an employment lawyer. What is a hostile work environment? That's probably a term that you've heard in the news or you've heard bandied about. But what does it actually mean? Hostile work environment is a specific type of lawsuit that you can bring under the California Employment and Housing Act and under the Civil Rights Act of 1964, which is a federal law. And specifically, a hostile work environment is severe or pervasive harassment because of a protected characteristic. And that last part is important because in California and under federal law as well, we do not have a general bullying statute, meaning that if you're just being bullied at work or you're just being harassed at work, but it's not because of a protected characteristic or because of a protected activity, then you're not going to be able to state a claim for that. I think someday we might very well have an anti-bullying statute, and I think we need one. But at this point in time, under the existing law, we don't have that. Now, what are the characteristics that are protected under state law and under federal law? Probably the one that is most associated with hostile work environment would be gender or sex, sexual harassment. That would be the most common one. But you can also assert a hostile work environment claim if you are subjected to harassment because of your race, because of gender orientation, because of disability, because of religion, because of veteran status. There's a pretty long list of protected characteristics that I will put in the comments down below. Severe or pervasive harassment is harassment that is hostile, intimidating, offensive, oppressive, or abusive, to the point that it upsets the employee's emotional well-being and makes it more difficult for the employee to do his or her job. Severe harassment, as you can imagine, that is looking at the severity of it. Pervasive harassment is looking at, is it ongoing, how often, for how long? And there's a couple of factors that juries are instructed to look at when they're trying to determine whether the employee has been subjected to severe or pervasive harassment. And they are instructed to look at the nature of the conduct, how often, over what period of time the conduct occurred, and whether the conduct was physically threatening or humiliating. And so, one thing a lot of people don't understand is that if you make one off-color joke, say somebody makes one sexist or racist joke, that's not going to rise to the level of severe or pervasive in most cases. Maybe there's some jokes that are so outrageously awful that maybe that could rise to severe. But generally speaking, one off-color joke is usually not going to lead to a successful harassment lawsuit. But the employer still has a duty and an obligation to put a stop to that conduct if it learns of it. The reason being that those off-color jokes, if they keep repeating themselves over and over a period of time, eventually that leads to pervasive harassment. And that's why an employee is protected if they report an off-color joke. Because even if that off-color joke standing alone is not harassment under the legal definition, the employer still is obligated to stop it so that it doesn't continue and does not become a pervasive environment. In addition to having to prove that the harassment was either severe or pervasive, you have to show that it was because of a protected characteristic. Now, one common misperception is that for something to be sexual harassment, it has to actually directly relate to sex, and that's actually not true. Same thing with racial harassment. The harassment doesn't have to actually mention gender. It doesn't have to actually mention somebody's religion or mention somebody's race. Okay, any sort of severe or pervasive harassment because of a protected category is going to suffice. So if the employer has a practice of severely or pervasively harassing women, but it doesn't harass men in the same fashion, that can be sexual harassment or gender harassment. I prefer the term gender harassment because it's a little bit less vague. But if the employer subjects employees of a certain race to a hostile work environment, but not employees of different races, that can satisfy the requirement of because of. Now, obviously, it's a lot stronger when the conduct directly references race or sex or religion or what have you. I mean, that makes it a lot easier to prove the because of standard. And sometimes something you see in some workplaces is that you have people who are equal opportunity jerks. They're just nasty to everybody. So that's always a challenge in cases where it doesn't directly reference race or sex or religion or veteran status or what have you. The next thing you have to prove is that the harassment was subjectively and objectively offensive. And subjectively offensive, that means that you, the victim, you were personally offended by it. And so one way an employer can defend itself in these cases is, say somebody makes, they make off-color race jokes every single day, but the victim is laughing at them all the time. The employer is going to argue that, well, it didn't actually offend him because he was laughing, he was smiling, and he made his own jokes. So that's one way an employer can defend itself. Now, employee will come back and say, well, I was faking it, I was just going along to get along. But that being said, those are tough cases when the employer can actually prove that the employee was, joking along and engaging in it. But your typical case usually doesn't have that. Now, the next thing they have to prove is that it's objectively offensive. And that is looked at from the point of view from the person in that particular protected category. So if it's a sexual harassment case, you're looking at it from the perspective of a reasonable woman. Or if it's a race case, it's of a reasonable person who's a member of that race. The next thing you look at is whether the harassment was by a supervisor or by a coworker, because that determines the standard of liability for the company, for the employer. Now, keep in mind, you can sue individuals for harassment. You can sue both the individual who did the harassment, and you can also sue the company. Okay, but to get the company on the hook for a coworker's harassment, you have to show that the company was negligent, that the company knew about the harassing conduct, should have known about the harassing conduct, and failed to take reasonable steps to stop it. I like to refer to this as the one free grab rule or the one free joke rule. Okay, one incident of severe harassment by a coworker is generally not going to be enough to get the employer on the hook. You have to show that the employer knew about it and failed to take reasonable steps to stop it. Now, the rule is completely different for a supervisor. The standard is called strict liability. And what that means is that if it's one incident, one severely harassing incident, the employer is automatically liable for it. And you don't have to show that the employer knew about it. You don't have to show that the employer failed to do something that could have stopped it. All you have to show is that there was severe or pervasive harassment by a supervisor because of a protected category, and that will establish liability for the employer. The next thing you have to show is that the harassing conduct caused you harm. Now, harm can be established by nothing more than emotional distress. If you got really upset by it and it made you sad, or it made you angry, or it made you feel humiliated, that's enough. Me personally, I've always been of the opinion that in the jury instructions, this should not separately be spelled out because it's redundant to the question of whether it was subjectively offensive. I cannot imagine a universe where something is subjectively offensive and doesn't harm you, right? It doesn't make sense, but that's where the law is today. So you do technically have to prove that element, but I would submit that if you prove that it was subjectively offensive, then you will have established harm. Don't forget to click like. Don't forget to subscribe. If you have any questions, you have any comments, just write them down below. If you need help with your legal situation, visit ortizlawca.com, ortizlawca.com, or call 888-37-ORTIZ. Thank you.